All rise. First District Court of Appeals now in session. All that business before this court draw near, give attention, he shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Welcome to the First District Court of Appeal. We have one case on our oral argument docket this morning, case number 25-1237, Dixon versus Brown. Mr. Bowen?
Thank you, Your Honors, and may it please the Court, Christopher Baum for the appellant. I'd like to reserve 3 minutes for rebuttal.
Noted. Thank you.
This Court should reverse because Mr. Brown has never been statutorily eligible to receive gain time, and the Department has never been statutorily authorized to grant gain time to someone who is ineligible. As a result, the Department's mistaken grant and subsequent correction did not violate the equal protection, the ex post facto clause. I'd like to start with the standard of review. This comes to the court as a direct appeal under Gould. So in Gould, the inmate asked the trial court to order the Department to consider him for incentive gain time. Here, Mr. Brown asked the trial court to order the Department to calculate and apply gain time. In neither case was the trial court reviewing any quasi-judicial proceeding for minimum standards of due process. There was no quasi-judicial proceeding. The petitioner asked for the classic mandamus relief. In his petition, he asked for the trial court to order the Department to perform a ministerial act to which he thought he had a clear legal right. And as a result, this comes to the court on a direct appeal on a question of statutory interpretation, and under Gould, the court's review is de novo. Turning to the merits, there's no question, and Mr. Brown doesn't contest that the 1994 statute applies to him and does not provide him with gain time. The 1994 statute says that it applies to him. It says that for sentences imposed for offenses committed on or after January 1st, 1994, his offense was committed in August 1994, the Department may grant incentive gain time in accordance with this paragraph. So this is the more specific statute governing Mr. Brown's offense. This is the newer statute governing it, and under expressio unius, the court should defer to the legislature's command that this is the statute that the...
I'm sorry, the statute is 944-275. What statute is this more recent than that we shouldn't be applying?
So in our brief, we make a distinction between provision subsection 4B, which we call the 1983 statute, and 4C, which we call the 1994 statute.
But in 1994, they didn't repeal 4B.
That's correct, and there's a very good reason for that, because if they had repealed 4B, that would have been removing gain time for all offenders between 1983 and 1994, and that would be a clear ex post facto violation. So they had to leave it on the books, which of course they did again in 1995. So the legislature couldn't simply delete the previous statute. But
so why doesn't B apply to Mr. Brown?
Well, first, because the 1994 statute says this is the statute that applies to him, because for offenses committed on or after January 1st, 1994, the Department may grant gain time.
That's all C, though.
Yeah, that's C.
C. I'm asking you why B doesn't apply to him instead of C. C definitely doesn't apply to him because he hasn't committed an offense that was level 1 through 10 at the time. But why not B?
But it is the statute that applies to him because it says for those offenses.
When you say statute, I assume you mean paragraph, right?
I'm sorry?
When you say statute, I assume you mean the paragraph?
Yes, that's right. So that's the paragraph that says this is how the Department may grant gain time to offenders who offended after January 1st, 1994.
But doesn't it cabin that by saying if you're within this category, these categories of crimes, and then it goes levels 1 through 10.
Yes, and it
Which
says,
he wasn't part of. 1
right, so
through
he is not entitled to gain time. Now, that,
10. Or
what
does
you're
he
asking.
switch into B?
Well,
Because B seems to be a catch-all, a broader category. It applies to any prisoner, any prisoner. But C applies to those who fall within levels 1 through 10 or not.
Right, and so he contends that the 1983 statute does apply to him. But that interpretation makes no sense. First, for the reasons that I stated about the 1994 statute saying, this is the one we want to apply for those offenders. But setting that aside, it would render paragraph 4C2 completely superfluous because in his view, he thinks that, well, in 1994, all the legislature wanted to do was provide an extra 5 days, so a total of 25 days for these lower level offenders. And then for the rest of them, 8 through 10, we're just going to keep it at 20. But why would it have to put in subsection 2 if you could already just go back to 4B and get those 20 days if you were one of those higher level offenders anyway? So it renders it superfluous.
Well, doesn't it really render it ambiguous as opposed to superfluous?
No, not at all. I think that if you use the tools of statutory interpretation, you can conclude that this is the paragraph that the legislature meant to apply to these offenders. And also, reading the 1983 statute to apply to him would mean that offenders level 1 through 10 would be able to would be entitled to a grant of gain time under both paragraphs, because nothing in either paragraph says that if you get gain time under one statute, under one paragraph, then you don't get it under the other. So an offender could say, I'm a level 7 offender. I get 25 days of gain time under 4C. However, I am also any prisoner, so I get 20 additional days under 4B, and that's surely not what the legislature
Well, that seems like an
intended.
ambiguity that would come up in another case, though. I mean, here we have a particular case that seems comparatively clean because it isn't a level 1 through 10. I get that there may be ambiguities or doublespeak as to levels 8 to 10 and maybe levels 1 through 10, but we don't have to deal with that right now.
Well,
what we have to deal with is his case.
Yes, but I think that you have to read the statutes properly to understand what the legislature was doing in 1994. And that's made clear by what happened in 1995, almost contemporaneously. The legislature said, yes, our view, appellant's view of the statute is what we meant, because it said 4B applies 1983 to 1994, 4C applies 1994.
Can the 1995 legislature speak for the 1993 legislature? Can it say this is what the 1993 legislature meant, so you need to apply the law as we say now in 1995?
No, that's not what we're contending. We're contending that it's evidence that the legislature contemporaneously understood what it was doing when it was setting it out. It had enacted a new gain time regime, so that was the third gain time regime. And then it looked at this and said, well, this looks kind of confusing because there's not end dates and start dates for everything, so we'll just make it clear that, this one is for these set of offenders, this one is for these set of offenders, and this one is for these set of offenders. And if instead it had been doing something other than a clarification of when the 4B applied, if it had instead said, by adding that end date, been cutting off the 1994 offender, like Mr. Brown, his entitlement to gain time under 1983 statute, that would violate the ex post facto clause, because it would be taking away something that he had been entitled to at his when he offended. But Mr. Brown has never contended that that's what the legislature did, and that it did there. So that's clearly not what the legislature was doing. What it was doing is it was saying in 1995, yeah, this is how they meant it 2 years ago. They put a start date on it, and they said, for sentences imposed for offenses committed on or after January 1st, 1994. That includes Mr. Brown. And it said the department may grant gain time in accordance with this paragraph, not 4B. And so under expressio unius, the court should defer to the legislature's choice to say, this is the paragraph you look to for these offenders. You don't look to that one. And with the 1995 clarification of which dates apply, I think it makes it perfectly clear that this is how each gain time regime was supposed to work.
You make an interesting observation that Mr. Brown never claimed that the 95 statute was an ex post facto violation. Was it? I mean, it did say, presuming the gain time has ex post facto effect, which I believe is undisputed, then it should, you would think that a statute changing gain time eligibility would only be prospective. And yet the statute explicitly said, no. For the people in the past who committed offenses, this is what the gain time eligibility is going to look like. Isn't that in and of itself an ex post facto violation, regardless of whether Mr. Brown argued it?
It would have been if that's what the legislature was doing. But I think, of course, you come to these statutes with the presumption of constitutionality, and you're not going to presume that the legislature intended to just cut all that off for those offenders. And instead, you're going to look at it and say, well, the legislature said that 4C is what applies 1994 going forward. And then in 1995, it said, yeah, that's how this works. You have the 1983 to 1994, you have the 1994 to 1995, and then you have the 1995 onward. So you shouldn't presume that instead what the legislature was doing was committing an ex post facto violation. So taking all of that together, you have 4C, the 1994 provision, that doesn't grant him any gain time. For the reasons that we've discussed, the 1983 statute doesn't apply to him and doesn't grant him any gain time. So the only remaining question is whether the department's mistaken grant of gain time and then subsequent correction of that misinterpretation constituted an ex post facto violation.
How mistaken was the department? As I read the 1994 rule, if this resentencing would have taken place in late 1994, say, my guess is they would apply the rule and would have granted the gain time.
They might have, but that would have been a violation of the statute.
Okay, so even DOC had it wrong in 1994 as to how they were interpreting this.
Not necessarily.
Yeah.
They had it wrong as to the 1994 offenders. But nothing.
Which is what we're dealing with.
But that regulation, let's say there was an offender in 1985, undisputedly entitled to gain time under the 1983 provision, right? If they were then resentenced to a term of years, that regulation could properly be applied to that offender to grant them gain time. But you can't do that with the 1994 provision because it's based on the offense severity levels.
Can I ask you a question about DOC's rule? You mentioned resentenced, if they were resentenced to a term of years, but the rule does not use the term resentence. It says in the event that the life or death sentence is commuted
Sure.
to a number of years. Do you just simply, I mean, commutation is something. It is not judicial. It's something that the executive branch does. It is something different than being resentenced by a judge. So are you saying that this rule does apply to resentencing in addition to commutation?
I think the rule has changed now, Your Honor, but if you were looking at in the past, would it have applied? I think there would have been an argument that under the department's rule that it only applied to commutations. But I think the rule said commutations because nobody was looking 20 years ahead and thinking about Miller and Graham and saying there's going to be all these resentencing.
Right, I agree. And that's one thing that's confused me about this case is before 2012, was there anybody who had a first-degree murder conviction? It wasn't reduced to a different conviction, to something that has a level, for instance, on it, but remained a first-degree murder conviction, but had the sentence reduced to a term of years, unless their sentence was commuted by the Board of Executive Clemency.
I'm not aware, Your Honor.
Okay.
But ultimately, I don't think the regulation has much salience here because, again, the department has no authority to grant gain time above and beyond what the legislature has granted. So the legislature says who is eligible. The department can't then come in and say, we're going to grant gain time to someone who is ineligible. It has no authority to do that. And that is why there is no ex post facto violation here, because Metheny in the 11th Circuit and multiple other decisions from circuits around the country have said the correction of an erroneous interpretation or policy even if it's a reasonable interpretation, does not implicate the ex post facto clause, because what you have to have is you have to have a delegation to the agency to make those substantive rules about, for example, who is eligible for gain
But
time.
my understanding is that that rule of law only applies if the statute is unambiguous and the agency's interpretation is clearly erroneous because the statute was unambiguous.
No, Your Honor, you need both. You need both ambiguity and you need the express delegation of legislative authority. That's what Metheny distinguished Nuck on, and that makes sense because the question in ex post facto cases is not just ambiguity, it's whether it's foreseeable. And it was foreseeable in 1994 that he would not be entitled to gain time under either statute. And even if there's a reasonable interpretation that says so otherwise, and that's what Metheny and all those other circuit court decisions stand for, which is there could be reasonable interpretations, so maybe there's some level of ambiguity. But when you don't have the lawmaking power as an agency, you can't create a rule that has the force of law implicating the ex post facto clause. I see that my time has expired. I reserve the remainder for rebuttal.
Very good. I'll give you a couple minutes on rebuttal, and please add a couple minutes also to Appellee's time. Thank you.
Thank you, Your Honors. Good morning. Matthew McLean on behalf of Mr. Brown, the appellee. I'd like to first thank the court for expediting this appeal and setting the oral argument so quickly. As the court is aware, if Mr. Brown is successful and this court affirms, he would be entitled to immediate release with the application of gain time, currently, which is in a stay at this point. At this time, I'd like to go ahead and try to make 2 points before Your Honors. The first one is the procedural, and which is the correct standard that this court is to review this appeal. It's our position that this court is limited to certiorari review, and the reason for that is pursuant to the Gould case. And the distinction between Gould and this case is that Mr. Brown's challenge actually involves a constitutional nature of the Department of Corrections decision, the ex post facto clause. Unlike in Gould, there was no constitutional challenge. It was a strict, we want to compel the Department of Corrections to apply gain time. The ex post facto clause is rooted in the United States and the Florida Constitution, and therefore that distinguishes it from the Gould case. And in Gould, this court recognized that issues that have to do with the constitutional nature of a proceeding should be reviewed by certiorari, not direct review. And the distinction is important because the standard this court applies in certiorari review is very limited. Pursuant to certiorari review, you look at 1 is procedural due process afforded, and 2 was the correct law applied. The Department of Corrections, in their initial brief, never asserted either of those being a problem here. So in addition to that, certiorari review and relief should only be granted when there's a departure from the essential requirements of law. And I find that to be a difficult position to take from the Department of Corrections, seeing as though the McGill case, which is on all fours according to the Department of Corrections and to Mr. Brown, is being afforded gain time under this provision pursuant to the federal district judge's order, which was initially appealed by the Department of Corrections but voluntarily dismissed. So to say that there's a departure from the essential requirements of law seems would be disingenuous based off that fact. Turning to the merits, as far as ex post facto violations go, there's a distinction between the line of cases. There's the Nutt case, and then there's the Metheny case line of cases. And the difference between the two is there being a retroactive interpretation of a clear rule or an ambiguous rule? And so really that's where this case boils down to. Is the court going to go ahead and find that the statute 944.275 is ambiguous, or is it clear? It's our position that it's ambiguous, and this has been found by the federal district court in McGill. It's also been found by the trial court. And so is it reasonable to believe that 2 judges who have looked at these provisions in 944.275, finding it ambiguous, that's strong evidence that this is an ambiguous statute. The Department of Corrections, when they read subsection C, I think they leave out key language. They don't read the entirety of the sentence. So turning to subsection C, for sentences imposed for offenses committed on or after January 1, 1994, and this is the part they leave out, for offenses which are.
I'm sorry, what version of
This is the
944-275?
1993, it was 1993 legislature passed the 1994 version that I'm speaking of, which is 944.275 4C. And it's the basically in subsection 4C, it's the final sentence. And the part they leave out is for offenses which are, were, or would have been ranked on the offense severity chart in section 921.0012. And then it goes on to list the 1 through 7 and 8 through 10. And that part they leave out is key because it's constraining the 1994 offenses to those that are ranked within the offense severity chart. Clearly, Mr. Brown, a capital offender, is not ranked in the offense severity chart. We're not here to go ahead and say he is. So when he's excluded based off of 4C, you look to whether there's any other subsection that would be applicable to him. And that is 4B. For each month in which a prisoner works diligently, participates in training, uses time constructively, or otherwise engages in positive activities, the department may grant up to 20 days of incentive gain time, which shall be
So
credited.
do we
and applied
know
monthly.
for a fact that subsection B applies to people with life sentences, in particular those convicted of capital felonies?
I think it applies to anyone outside of the offense severity chart. So if there's
No, forget the offense severity chart. Let's talk about prior to C being enacted. Does it apply to people with life sentences? And if so, how?
I mean, it would apply if there's life sentences are commuted to a term of years or reduced to a term
And
of
that's
years.
what the rule says. If it's commuted to a term of years,
Correct.
then you can receive, not calculate, not get for record-keeping purposes, but actually receive gain time.
Correct.
Does somebody whose sentence is not commuted and has a life sentence, can they ever receive any kind of gain time?
I think
Under
that-
the 83.
I think they
under
could
subsection
certainly
A.
receive gain time, but it would be, meaningless because they have a life sentence. So if you want to reduce a life sentence with incentive gain time, then certainly you can go ahead and get it pursuant to subsection 4B. Nothing would prohibit the life sentence from being, in theory, reduced by 20 days each month. But once that term goes from life to a term of years, then it matters. And in Mr. Brown's case, he's got over 10 years of incentive gain time at this point. Only 2 years left on his sentence. So in a way, he's been incarcerated for over 8 years and more than he should have been.
So did the department have an interpretation that this applies to people who have a first-degree murder conviction? It doesn't get reduced somehow to a lesser offense, but have a first-degree murder conviction, but somehow are able to obtain a term of year sentence.
That's why they
Well,
recorded it.
has that ever happened before 2012?
Before 2012, no, I don't know of
Then
any sort of situation.
why is it that the department had a policy which allowed people who have life sentences to be entitled to gain time if that has never happened? It's never actually been done.
Well, I think they did it in the event that it might happen. So I don't know what they were foreseeing, but if you look at the testimony that's included in the record from the McGill case, that was their policy, is they're going to go ahead and record incentive gain time in the event that...
There's nothing wrong with recording incentive gain time for the purpose, at least according to the rule, that the inmate ends up getting a commutation. Doesn't say resentencing. It doesn't contemplate that the Supreme Court's going to strike down part of our capital sentencing structure.
Sure.
It says commutation.
It does say commutation, but I think aside from it saying commutation, the point here is it authorized by statute, the incentive gain time, and 944.275 subsection B says it is, and capital offenders or life sentences are not excluded. There's nothing that excludes him from getting incentive gain time, and the administrative rule, if it is limited to commutation in that setting, then it was wrong, and they do have authority to grant incentive gain time under 4B. And that's exactly what they did. There's situations where they've released inmates based off incentive gain time similarly situated to Mr. Brown. The most
And they're
notable-
saying that they did that in error. That happened a couple of times and that it happened in error. So it wasn't like a policy that they've been using since 1994, 1983, or whatever. It is something that happened in the wake of Miller when nobody knew exactly how we were going to sentence people. And so they ended up releasing a couple of people, and later they said they did that in error.
So Powell, for example, was released on incentive gain time, and then they realized, according to them, that they made an error. To Mr. Powell, they never rearrested. So how did he get out without incentive gain time being applied? So they release Powell, and they say, we don't have authority to give him gain time, yet we're not going to require him to fill out his entire sentence. So, Mr. Powell's a great example of incentive gain time being applied to an inmate. And it wasn't until 2016 that this issue came up in the Purdy context when the state attorney reached out and had the general counsel look into this issue and make a decision on the facts. And I think what's important to know is that in 2016, and this was really kind of flushed out in the district court level, is that they were reading the wrong statute, most likely. They were reading the 1995 version of it. It didn't come up until the federal district court proceedings where subsection 4B was even discussed. To me, I think the Department of Corrections clearly believes that there's an interpretation where Mr. Brown and like inmates are disqualified, but there's also the reasonable interpretation when what makes it ambiguous that he is. And so the Department of Corrections tracking, granting gain time to individuals under this subsection also goes to show that this was an ambiguous statute. And when you look at, what would be the purpose, and this is also laid out by the federal district court, of excluding 9 inmates from gain time. So inmates that fall outside of 1994 to October of 1995 are the only inmates of capital offenders, if their sentences are reduced a term of years, who are disqualified from incentive gain time. That doesn't make any sense. When we look at also, what the purpose of incentive gain time is to go ahead and encourage good behavior within the prison system. And that's exactly what Mr. Brown was doing to get gain time. They were giving him monthly notices after his resentencing in 2014, I believe it was. He asked, how much gain time do I have? They gave him an information sheet showing that his release date is 2039, but his tentative release date is 2031, an 8 years difference, applying the gain time rule. So we believe that there's ample amount of reasoning to find 944.275 to be ambiguous, and under NUC, an ambiguous statute that is interpreted subsequently, retroactively to the detriment of the petitioner is an ex post facto violation that needs to be cured by this court. Mr. Brown remains incarcerated at Sago Palm Correctional Institution. We're asking this court to immediately lift the stay in place. We're asking this court to affirm the trial court's decision. If there are any other questions?
I'll ask you one about you're relying on NUC. Can you tell us how you would distinguish NUC and metheny? Why should NUC control rather than metheny?
So I think the distinction that can be made is there an ambiguous rule? And so when you look at metheny, metheny was a situation where they were changing their interpretation of a clear rule, and they used the word clear, whereas NUC, there was a change of interpretation of an ambiguous rule. So the difference between the two is NUC controls when the statute or the rule is ambiguous, and then metheny would control.
I'm sorry, go ahead.
Yeah, the metheny would control when it is a clear rule.
What is the change in interpretation?
The change in interpretation is whether he's entitled to incentive gain time or for consideration of it. So
Consideration?
Consideration
Or
of,
actually award? I mean, my understanding is that the department has always said, well, we're going to go ahead and count it up. We're going to go ahead and say that, hey, you get 20 days of incentive gain time for this. But this is what I've been trying to ask. When has it ever been awarded? In other words, I don't see that the department had a rule or a policy that gain time would be awarded to anybody who has a life sentence unless their sentence has been commuted, explicitly commuted.
Well-
So I don't understand why there's what interpretation, unless you're just talking about just, what they said to your client or to, any one of the other 9 inmates, constitutes, a rule of the department.
Well, I think it's been the Department of Corrections' rule is that he's disqualified at this point based off their new interpretation from gain time. So under the line of cases that we're relying on, you can't compel the Department of Corrections to afford a certain amount of gain time, but you can compel them to find that he's not disqualified and consider him to incentive gain time. And I'll point, to McGill himself, the federal district case where the inmate was found to have an ex post facto violation, and the Department of Corrections was compelled to go ahead and consider him gain time. And this is in the record. Mr. McGill is being afforded gain time. His sentence date, as far as the record shows that we provided, is now 2027, who has a longer sentence than Mr. Brown. So currently, Mr. McGill is getting incentive gain time under the statute. And it certainly would seem to be odd where you have an identically situated.
Well, that's because the department was ordered to do that by the federal court, right? That's not because they are interpreting the statute that way or because they think it's an appropriate application of their rule.
I mean, certainly they're being ordered to do it, but they didn't go ahead and appeal to the 11th Circuit and continue to pursue their rights to litigate the issue. So it shouldn't be a matter of forum shopping to go ahead and get different decisions on the same issue. There's literally 4 inmates now in the Department of Corrections that this is applying to, and at least one of them is getting it. So it doesn't seem quite fair to allow one, based off of a different forum, to get relief, whereas the other doesn't. So again, we're asking the court to affirm, lift the stay immediately to allow for his release.
Thank you, Mr. McLean.
Just a couple of quick points. Metheny did not distinguish NUC simply based on the fact that there was not an ambiguous statute. It, like other federal circuit courts of appeal, have also distinguished NUC on the basis that it involved an express delegation of legislative authority to agencies. So you only have an ex post facto violation when there's a legislative act. And that, when you have an agency, you don't have a legislative act unless the legislature says, you, the agency, have the power to make a substantive rule governing this issue. And so, for example, if the legislature had said the department can make rules about who is eligible for gain time, and it made a rule in 1994 saying that Mr. Brown was eligible, and then it went back and said, no, he's not eligible, that would be an ex post facto violation. But when all that you have is an interpretation of a statute, even if there is some ambiguity, because there's, for example, a reasonable interpretation to the contrary, as in Metheny, that cannot be an ex post facto violation because there's no change in law. The statute has never changed. And so his sentence has not been increased by any misinterpretation by the department. So unless the court has any further questions, the department respectfully requests that the court reverse.
Thank you, Mr. Bond. All right, that's our only argument for today. We are adjourned.
All rise.